This is just a little bit about myself. I'm a ranch consultant. I'm an adjunct professor at Texas A&M University. I teach agricultural economics and natural resource economic courses online for Texas A&M. And can you guys hear okay? Can you hear that all right? Okay. So, just to give you a little background on myself, I worked for the federal government. I had 16 and a half years in, so I know both sides of the fence. We owned a ranch with a BLM, big BLM allotment down in Arizona. My wife was fifth generation down there on that ranch. And we owned, we're partners in that ranch for about 20 years, and when we sold it a few years ago to a relative, it's still in the family, to a cousin. Our situation there was we had 10 partners in that ranch, and when you got that many people trying to run the show, it just doesn't work out. So that's why we ended up selling that ranch. But I've worked, like I said, I had 16 and a half years of federal service, and most of that was with USDA. Some of it was with the NRCS, and some of it was U.S. Forest Service. And that's where I really got my interest in this subject about property rights on federal land. And words have meaning. As I started doing my research, what I found out is that words have meaning in the law, because when you start looking at some of these statutes that created some of these different agencies, created forest reserves, grazing districts, so on and so forth, national parks, the one thing I found out was this term public land had a definite, defined meaning in the law. And you know, I see people use it, and I hear people use it, and they throw it around kind of as a catch-all, but in reality, that term public land has a very distinct, defined, well-defined meaning in the law. It would be the same as me going into court and arguing about some kind of violation because I was driving a Volkswagen Beetle, and that particular law had to deal with commercial motor vehicles. Well, there's a definition of what constitutes a commercial motor vehicle. If it doesn't weigh so many tons, if it's not a semi or something along that nature, it's not a commercial vehicle. So if I got accused of violating some statute or law that has to deal with that, the operation of a commercial motor vehicle, and I'm just driving my Volkswagen Beetle down the street, there is a difference in the law. Okay, and so this term public land has gotten a lot of people confused, twisted around. Public lands are not this catch-all word that people use for anything that happens to belong to the federal government. There are different laws that pertain to forest reserves than there are from national parks. There are different laws that pertain to military lands than to BLM grazing districts. And so you can't just call everything public land and think all the same laws apply to that. And that's one thing I found out as I started doing this research. I'm still a youngster at this. I've only been doing this for about 26 years. But in that time, I was able to make good friends with people like Wayne Hage Sr., and his family. Ramona probably remembers me from when she was, you know, fairly young. She's a few years younger than me, probably in college. Wayne was, I think, 15 or 16 years old when I first met him, Wayne Jr. So, you know, but some of these people have been involved for a lifetime. You know, you've got DeMar Dahl, you know, and you know, I had the privilege of meeting his dad at a meeting in Eureka back 20 years ago. You know, I've been involved in this for quite a while, and my original intent when I got involved in this was I just wanted to know what was the truth. What were the facts? What was the law? I didn't have any preconceived ideas or notions. I just wanted to know what the facts were. And there wasn't any place where there was a book that was published that had all of these statutes in there, because I knew that my opinion or anybody else's opinion really is irrelevant. What matters in a court of law is what the law says. So I decided I was going back to the origins. I'd find out, you know, and what really got me going was Wayne's book, Storm Over Rangelands, Wayne Hage Sr. I was working with the Forest Service at the time when I got my first copy of that book, and Cliff Gardner, who's not here today, he was here yesterday, he was the one that got me to buy that first copy. I met him at a Range Society meeting in Reno back somewhere around like 1989 or 90, somewhere in that time period, and he was running a booth and selling books. And I got a copy of the Storm Over Rangelands, and I started reading it, and I was fascinated. I couldn't put it down. I had to read the whole thing through without stopping, because the subject was just so incredibly fascinating to me as a federal employee working for the Forest Service. You know, I was already of a mindset that I felt I was a pro-rancher type individual anyway. I thought ranching's a good idea. There's nothing wrong with ranching. It provides food for the American people. So that's what got me started on this. But I found that as I started doing my research, there was a big disconnect between what the law said and what was actually going on. And so there was friction, I guess you could say, or disagreement at the minimum, between some of my Forest Service supervisors and myself. And eventually, after several years, I decided, you know what, I need to go do something about this. If I really want to find out more information about this, I was going to go back, study this topic, and I found a professor at New Mexico State University who said, yeah, that sounds like good research. Come on down here. And that's what I did my doctoral dissertation on. And so in the meantime, I had been researching this topic, looking at the laws. Okay, so first off, what are property rights and how are they created? Because if ranchers have property rights, what is property? This is a definition of property given by John Locke. And what I found is that this definition is what predominated in the minds of all of the legislators in the House of Representatives and the Senate down through time throughout the history of our Congress. And this is called the Lockean concept, because it was penned by John Locke. But him and Adam Smith were the two most influential, most often quoted in the congressional record philosophers of this Scottish Enlightenment period, which was influential on our founders. And this is their concept of property. Though the earth and all inferior creatures be common to all men, yet every man has a property in his own person. The body, this nobody has any right to but himself. The labor of his body and the work of his hands, we may say, are properly his. Whatsoever then he removes out of the state that nature hath provided and left it in, he hath mixed his labor with it and joined to it something that is his own, and thereby makes it his property. It being by him removed from the common state nature placed it in, it hath by his labor something annexed to it that excludes the common right of other men. In other words, if this was a wilderness, nothing was here, nobody was living here, it's God put it here, all right? Anybody could then come into this area, a pioneer could come in here, cut down a bunch of trees, skin the logs, notch them, stack them up, and build a house. He has now mixed his labor with that resource. And now there is something annexed or connected to those logs that make those his logs, his house, his property, because he has mixed his labor his blood, his years with this. And he has the right to use force if necessary to defend his property from someone else coming in to take it. Now, if somebody else had come in before him and had cut down these same trees, mixed their labor with it, then it would be their property. Now, he could come in afterwards and say, hey, I'll give you 2 horses for this house. Well, that's up to them then. But that first person to come in, mix their labor with it, improve it, possess it, live there, spend their time there, and improve it, this was the concept of property that prevailed in the minds of our ancestors. Okay, so in the early days of the United States, there were vast amounts of lands west of the Appalachian Mountains, claimed by some of the states as territories. The smaller states refused to ratify the Constitution until the others gave up their claimed Western territories for the mutual benefit of them all. This resulted in Article 4, Section 3, Clause 2 of the Constitution, which says, Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. Now, there are some people that have the idea that from the very beginning, the original founding states were supposed to give all of this land that, for example, Virginia had land claims that extended all the way to the Pacific Ocean. But the other smaller states, Delaware, New Jersey, Massachusetts, Connecticut, the ones that basically were landlocked and had, or ocean locked on one side, they didn't want to allow these other states to have this vast, huge amount of territory they claimed as their own. They want them to give it up for the benefit of all the states. So, and the idea was not that they were going to reserve this land and then give it to a new state whenever a new state was formed, because that's exactly what they were getting rid of with this English rule. In England, the king or the state owned everything, and you were merely a tenant on the land at the will of the government. What they wanted was a nation of property owners, landowners. And so as these territories became settled, people acquired property right in this same concept, this Lockean concept. They actually went out, occupied the land, built farms, built fences, improved the land, and put a time period in, and thereby, by their own possession and occupancy and use, made it their property. Okay, the idea was not to create a state where the state owned all the land and everybody was just a tenant that ended up paying rent to the state. This Lockean concept of mixing your labor, time, and effort with natural resources to create property rights runs like a consistent thread through all the public land laws of the United States. The idea of settlement, appropriation, possession, occupancy, and use, these are all words used in these statutes, these public land statutes, the preemption laws, the homestead laws, the mining laws, the Desert Land Acts, the Reclamation Act, the water rights laws, the right-of-way and easement laws that Congress has passed, all have this same language in there. Having established a possessory right, this gave the settler a preference right to acquire the legal title from the United States. And this word preference, these are all words used in all of these statutes. And this, where Congress would grant a preference right to whoever had originally gone out and settled on land, because a lot of this land, you take New Mexico, for example. There were people living in New Mexico, in southern Colorado, Arizona, California, long before that became part of the United States. When, after the Mexican War, the Treaty of Guadalupe Hidalgo said that all the rights, all these people already in possession and occupancy of this land would be respected in their rights. This was a principle accepted by all the nations at that time, whether it was France, England, or Spain, or Mexico. This concept of possession and possessory rights prevailed under all of these international laws. And so these people's rights were respected. The only proviso being that there had to be this concept of permanent settlement, possession, occupancy, improvement. This was their view. And this was under the Spanish law, for example, the Comanche type Indians that were nomadic, hunter, raider type individuals, they did not recognize a property right under the Mexican and Spanish law for these people. However, the Pueblo Indians, which were settled, they were settled in a specific area, they had defined limits of their territory, of the land they claimed, they had improved the land, they lived on it in permanent structures. That was the difference. And I'm not saying whether it's right or wrong, I'm just saying this was the political view of property that prevailed in the United States. And so until an Indian tribe that was a nomadic tribe, until they actually signed a treaty and defined boundaries of what was their territory, they were not, their property rights were not considered settled in the courts or under the laws of Congress. But once that reservation was made and the territory defined, that became their land, Indian land. For the first 200 years, Congress enacted hundreds of statutes for the purpose of disposing of the public lands to states, railroads, Indian tribes, and to, quote, the bona fide settlers, occupants, and miners in the actual possession and use of the land under a classification system. Under this classification system, they would classify land. Okay, is it agricultural land? Is it mineral land? Is it swamp land? They had this classification system, and based on how that land was classified, that would be what law you could claim under. Well, that worked really well in the East. And we'll get into this a little bit more, but as people progressed farther west, this classification system didn't work. The term public lands, and this is what I was talking about before. This term public lands was clearly defined by the Supreme Court to mean lands open to entry and settlement upon which there are no rights or claims. Okay, the very moment a settler moved onto a piece of land, staked the corners, and began a permanent occupancy, that land ceased to be public land. It was no longer legally public land. Why? Because now someone has made a claim to that. Someone is mixing their labor with the land. They are improving the land. That excludes the common right of other people to now come on there. Now, there were people called claim jumpers who would try to file a claim over the top of land that someone else had already settled on, that there was already possession on. And a lot of the people in California and New Mexico, in these areas that were pretty much generally settled, there was a lot of issues and a lot of problems with them. One thing being, most of them spoke Spanish, didn't understand the English language. And so there's a lot of history there with those kind of conflicts. But this was the thing that the Supreme Court said. As soon as a right of any kind attaches that land, it ceases to be public land. The principal policy of Congress was to grant, under these homestead laws and preemption laws, and you can go back and read the language. It's clear in all of these statutes. The policy of Congress was to grant to the head of a household or to sell at nominal cost agricultural homesteads of a size sufficient for the support of a family. And that's a quote. Now, under the original homestead laws, as we moved along, as people move farther west, first they start out with 160 acres, then they increased it to 320, then to 640. And Congress was reluctant to grant lands in larger quantities than that primarily because of the valuable minerals. And that's where this classification system eventually turned out to be unworkable, because as you move farther west and you get into these arid, mountainous lands, well, what is exactly agricultural? What is suited for irrigation? What is really mineral land? If there's no valuable minerals that they considered gold, silver, copper, cinnabar, these were some of the minerals that they considered as valuable minerals. You know, if you can detect it, is it valuable for minerals? Plus, you had the issue of you can't make a living on 160 acres in central Nevada. Okay, I don't care where you're at. There's no place that you can. So, but they didn't want to give away 160 sections that would be necessary to make a living on, because there might be valuable minerals. So this was kind of a conundrum that Congress struggled with. And before Congress enacted a grazing law, because a lot of the land wasn't suited for tillage, wasn't suited for raising crops of any kind. So as they got farther west and they started trying to settle all these different land claims, and because people had moved out, settled on the land, the territories and states didn't just sit around waiting for Congress to finally come up with a law. They started passing their own laws, these territorial range laws, okay, to recognize range rights. Now, before we keep going on that, I'm going to real quick talk about what is real property or real estate. And these are definitions. None of this is just Angus McIntosh's opinion. Okay, this is stuff that comes right out of the authorities and the definitions from the various different state laws on defining what's real estate. A specific geographically defined area of land somewhere on the surface of the earth. That is real estate. It's got a GPS location, it's got longitude, latitude. You can actually locate it. That is real estate. Now, real property is not necessarily real estate. Somebody could own, Ramona might own 100 acres of real estate, okay? But there could be various different real property interests involved in that land. I could own an easement across her 100 acres. So even though she owns the land, I have a real property interest in that 100 acres because I could own an easement. Somebody else could own the mineral rights. Somebody else could own water rights. There could be a ditch that flows through that, or a stream, we'll say a stream that flows through that 100 acres, and there can be 10 different owners of the water rights that flow through that stream. So this is what's known as a split estate. So you've got real estate, you've got real property, which is a fractional interest in real estate. It could be water rights, mineral rights, easements, timber and stone rights, possessory range rights. It can also include permanent improvements, corrals, forage, etc. A split estate is typically divided surface and mineral, but the courts have also said it can be any fractional or undivided interest. Sometimes it's called multiple estate or multiple use land. Personal property, that's anything that's movable, your cattle, horses, a trailer, your pickup truck. So these are different types of property. So when we talk about property, property can be various different things, but it's not necessarily real estate. Range rights. Okay, we were talking about the settlement of the West. Well, as people progress farther west, this idea of range rights was not new. This was an idea and a law and custom that existed under Spanish and Mexican law in the West, and a large part of the West was already settled. And these type of customs that were suited to the country already existed. One of the first acts of the California legislature, which was one of the earliest western states to become a state in 1850, one of the first acts of their legislature was to reenact as state law their jueces de campo and their water laws, New Mexico, the acequias. So this idea of water rights, split estate water rights, of range rights, the rodeo laws that California passed, they were simply a reenactment of the laws that already existed under Spanish and Mexican rule. Also, General Kearny, when he came in to Santa Fe in 1846, the first thing he did was he sat down with all of the legislators and the politicians there and said, listen, you know, we're not taking anybody's property. We're not booting anybody out. We're going to respect everybody's property rights. Instead of pledging allegiance to the President of Mexico, you're going to pledge allegiance to the United States government. Instead of being a Mexican citizen, you'll be a U.S. citizen. And so he developed a code. It's called Kearny's Code. It's still in the law in the state of New Mexico. It's in the revised statutes. You can find a copy of it. And the Supreme Court has ruled at least on 6 different occasions that Kearny's Code was as valid as any act of Congress. Because under martial law, General Kearny was the executive, legislative, and judicial branch of the United States government. And so Kearny's Code has been accepted in the courts in a very important water rights case that went to the U.S. Supreme Court. The Supreme Court said Kearny's Code was the law. And it carried into effect on page 71, particularly all the laws pertaining to water rights, range rights, and the customs that had existed under the Spanish and Mexican rule. Here's some of the cases that deal with this idea of forage rights as a property right, possessory right. Atherton versus Fowler, 1877. This was a guy in California. He had settled on a piece of land, hundreds of acres, bigger than anything you could get under the preemption or the homestead laws at that time. And it was assumed that it was part of a valid Mexican land grant. Later on, it was determined that it was not valid, and that overnight, technically, the United States became the owner of the underlying land. But yet the Supreme Court said that even though the United States was the owner of that underlying land title, it was not, quote unquote, public land. And the reason was because it was in his actual possession, occupancy, and use. And it didn't matter that the amount of acres that he had far exceeded what was allowed under the homestead laws. As long as he was in a valid possession under the state law of California of that range, that was a valid property right, good against the entire world except for good against the United States. But even the United States, the Supreme Court said, could not dispossess him in order to give that land to somebody else. What that case was about is somebody claimed, well, the United States owns the land. That's more land than he can get under the homestead laws, so I'm going to go on there and homestead. And it went all the way to the Supreme Court, and the Supreme Court said, no, that is not public land, and you can only file a claim on unoccupied public land. And as long as he was in the actual possession and use, there was no way the United States could give that land to him. Okay? Now, they left the question open, and it was answered a few years previous, but, you know, if the United States wanted to come in and now convert that to some federal use, like a national park, that was a different story. But as far as the government giving that land to anybody else, they couldn't do it because he had a valid property right, a right of possession. And in this case of Griffiths versus Gotti, 1885, that was the first specific range rights case. And under Atherton versus Fowler, they said that he had, even though the legal title belonged to the United States, Atherton owned that forage that was growing on that land. And this homesteader that had moved on there and tried to claim it, he had cut it for hay, and he ended up owing Atherton for the value of that forage. So based on these cases, the Supreme Court built up this body of case law so that if you are familiar with, for example, the Taylor Grazing Act, why does the next guy have to pay you for the value of that land and your improvements before they can give a new permit to the next guy? Does that make sense? Anyway, So, water rights. We're talking about split estates. Kearny's Code continued Mexican laws of prior appropriation water rights, and these were adopted in state and territorial laws. Congress validated state and territorial water rights by Section 9 of the Act of July 26, 1866, and severed all water in the West from the public lands by the Acts of 1866, 1870, and the Desert Land Act of 1877. That's the language from Justice Rehnquist in California versus U.S. in 1976. So this isn't some ancient decision made by the Supreme Court sometime back in the 1800s. This is modern law. In the same year, Rehnquist wrote the majority opinion also for U.S. versus New Mexico. In that case, the question was who owns the water rights, the stock water rights, in the national forest, and does the federal government have what's called reserved water rights? That's a whole nother seminar right there. Reserved water rights for, and they were claiming a whole myriad of uses: wildlife, fisheries, in-stream flows, aesthetics, recreation, all kinds of things they were claiming water rights for. That case is well worth reading because the Supreme Court said exactly what national forests were established for: two purposes and two purposes only: provided continuous supply of timber to meet the needs and necessities of the settlers of the arid West, and to enhance water yield in order to make that water available for appropriation by private citizens. And if the Supreme Court now accepted this argument that the federal government had all this myriad of water rights for wildlife and everything else, it would actually defeat the very purpose for which forest reserves were created in the first place, which was to enhance the amount of water available under the prior appropriation doctrine for appropriation by private citizens. So that was their logic. And they even went on to compare forest reserves to national parks, saying that national parks were the places created for recreation and aesthetics and for environmental purposes. They specifically say national forests were not created for aesthetic, recreation, environmental, or wildlife preservation purposes, period. So they were created for economic use. And that's the Supreme Court talking, not Angus McIntosh. That's why I give all of these references in my presentation. And as a matter of fact, well, I am selling these. But, you know, they cost $10 just to get them printed. And we try to make enough money just to cover my gas and everything. So $20, you can get one of these. If you don't have it, it's full of the bibliography, as all of these court cases, all of the statutes, page after page in the back, copies right out of the congressional record, so you can read what Congress said. You don't have to take Angus McIntosh's word for this stuff. They're right out front on that table out front. And just for some of the, well, I don't know if you can see it that well from up here, but these are just some of my more recent notes that I've added in there. And I took all of these additional notes, and on the table yesterday there was a handout, and I just wrote kind of a synopsis to try to boil this down. So if you got that 4-page synopsis that was laying on the table yesterday, and if you didn't, when I had these printed up, I had that same synopsis inserted in the front. So it's the second page in here, and it's a kind of a narrative chronology, and that's what Tim wanted, so it's something that people could read and understand. It's just 4 pages, but it kind of boils down this presentation, this research, to something that you can understand. But basically we have split estates, and they were created by all these acts of Congress that Congress passed. State and territorial laws recognized easements for livestock, irrigation, mining. Here's a couple of the cases that talk about it. Section 8 of the Act of 1866. That act, the Act of July 26, 1866, I think personally, if you had to identify one single act of Congress, it's the single most important act for the West that Congress ever enacted. I'll talk a little bit more about this case of Curtin versus Benson. It had to deal with a rancher and right-of-ways. Colorado versus Toll, 1925. It affects county roads. Every county road or state highway that crosses federal land anywhere in the West has as its authority this Act of July 26, 1866. If you've heard RS 2477, that's what it is. It's Section 8 of this Act of 1866. The Mexican custom and law recognized a right of local residents to use stone and timber and related products for construction, firewood, and other uses. Congress passed acts in 1878 making it actually a criminal defense if you were arrested or charged with taking government property. You're actually excused by just saying that, hey, it was for my own personal use within the boundaries of the state. The forest reserves were created for the benefit of the citizens of those states that those forest reserves were in. And this is a consistent thread through all of these acts of Congress. Congress encouraged the establishment of family-sized ranch units throughout the West by passing laws to grant and confirm specific property rights to settlers while reserving other interests for separate appropriation. These are under all the various homestead laws. The real culmination of this was this change in policy came with the Reclamation Act in 1902. It is well settled that all land to which any claim or rights, this is a quote from the U.S. Supreme Court. Let's see, it was well settled that all land to which any claim or rights of others is attached does not fall within the designation public lands. And this has to deal with even a right-of-way. Even a right-of-way would take it out of the class of public land. As the grant of the right-of-way, the filing of the map of definite location, and the construction of the railroad within the quarter section in question preceded the filing of the homestead. This was a contest between a railroad company and a homesteader. Homestead entries on such section, the land forming the right-of-way therein was taken out of the category of public land subject to preemption and sale, and the land department was therefore without authority to convey rights therein. Let's see what. That was Northern Pacific Railroad versus Townsend. And like I said, any of you attorneys in here, go to Words and Phrases, Corpus Juris, American Jurisprudence, Black's Law Dictionary. Look this up yourself. There's at least 16 Supreme Court decisions on this one issue, the definition of what is public land. Through a series of statutes passed in the 1800s and early 1900s, Congress sanctioned, confirmed, and granted split estate property rights to settlers in the region west of the 100th meridian. These statutes granted and confirmed water rights, easements, grazing allotments, and forage and improvement rights, mineral rights, and timber use rights. A really good case to understand this whole split estate concept and how Congress, see, they debated how are we going to dispose of these grazing lands, lands that's valuable for grazing. That was debated there was a new law introduced in Congress from 1899 every year, from 1899 to 1916. For 17 years, Congress debated and argued how are we going to dispose of this land. And the real solution came when Teddy Roosevelt, in his address to Congress in 1909, said, you have to create a split estate. The federal government keep the timber and the minerals and dispose of the service to the ranchers in areas of land large enough for the support of a family. And so the first act that Congress had passed, they'd already basically moved on or started to adopt this concept with the Reclamation Act. And if you read the Reclamation Act, Section 3 spells it out. It's called the unit policy. And a lot of people have never heard of it. I hadn't either before I started doing all this research. But Congress adopted what was called the unit policy. And a unit is an area of land sufficient for the support of a family. And it didn't matter since they created this split estate. Well, now it didn't matter if a rancher got 160 sections because the minerals were still reserved and were still open for settlement or claiming by a mineral claimant. So even though the rancher owned the surface, the government retained this right of entry for someone that was a miner or prospector to go onto that land to continue looking for minerals and develop minerals. And as a matter of fact, in the regulations of the Interior Department issued the year following passage of the Stock Raising Homestead Act in 1916, Congress the Interior Department issued new regulations saying anyone who files for a mineral claim after that date would only get title to the minerals, not the surface. Why? Because the whole West by this time was already settled under this right of possession, and they already had these preference rights. And so in the Taylor Grazing Act, when it talks about the preference right, what are they talking about? It's a preference to the actual title of the land itself, to the surface estate. A limited surface title is what Congress said. In this case, Watt versus Western Nuclear, 1983. This is an ancient law. The Supreme Court talks about it. Read the whole case, read the majority opinion, read the dissenting opinion, read all the footnotes, and it expels it out. But this was the policy that Congress adopted, because what did Article 4, Section 3, Clause 2 say? Congress has the power to dispose of. That was their main intent. Their main intent was to dispose of the land to actual settlers, and this is how they did it. Okay, the nature of the land in the West was so physically different than the East, Congress established two separate land settlement patterns to accommodate the conditions that existed in the West. California versus U.S. talks about it, Watt versus Western Nuclear. These are just, you know, most of these laws are found under Title 43 of the United States Code, which is entitled Public Lands. Now, they set this system up for the United States Code over 100 years ago. They just never have changed any of those titles. You know, the title dealing with Indians, well, now they prefer being called Native Americans. Well, the title still hasn't changed, even though every law that has to deal with Native Americans is classified under that heading, just like everything that has to deal with national parks, national forest, everything else are classified under this title Public Lands. And I think that has led to the confusion of people thinking they're public lands, when in reality they're not. Even without any property rights consideration, a national forest is still a withdrawal. It has been withdrawn from the public lands. It's a reservation. BLM land, originally they were withdrawn under executive order under an act that was passed in 1910 in order to establish what are called grazing districts. So what kind of an entry or settlement can you make in a national forest or a BLM grazing district today? What kind of an entry? Can you homestead there? No. The only kind of entry you can make is a mining claim or an oil or gas lease. And that's because it's no longer public land. It's split estate land. They're withdrawn, they're reserved, and and once land is reserved by the federal government, you can't make any kind of entry on there without the permission of Congress. Okay, and the Forest Reserve Organic Act specifically excluded all land more valuable for agricultural or mining purposes. So those were the only kind, and then in 1906, Congress specifically enacted the National Forest Homestead Act. And if you read the National Forest Homestead Act, it contains the same exact language as the Reclamation Act in 1902, because Congress had now adopted this unit policy. They were no longer going to confine a homesteader to 160 or 320 or 640. It was an amount of land sufficient for the support of a family. And so in any of the following statutes where they use the term unit, that's exactly what Congress is talking about. It's a unit, a farm unit or a ranch unit, was an amount of land sufficient for the support of a family. Now, here's a map from 1879 report of John Wesley Powell to Congress, and in 1890, Congress enacted a statute which set the 100th meridian as the dividing line between the riparian and the prior appropriation doctrine. And that's not my interpretation. That is exactly what William Rehnquist wrote in the California versus U.S. decision, that 1976 Supreme Court decision. Okay? So he said that those three acts, the Act 1866, 1870, and the Desert Land Act of 1877, severed all the water in the West, including groundwater, from the federal land. So this riparian doctrine, what do they try to foist on you today? They talk about, well, riparian this, your riparian area sucks, your riparian area, you know, is getting overrun by cows, so on and so forth. Well, guess what? The riparian doctrine of law does not apply in the state of Nevada. In Arizona, their state constitution specifically says the riparian doctrine will be in no force and effect in the state of Arizona. Now, words have meaning in the law. Okay, you can call it riparian, you can call it you can call it a silk, a silk purse, a sow's ear, whatever. It doesn't make it so. Okay, words have meaning in the law. If it's a reservation, it's not public land. If it's a grazing district, it's not public land. Okay, and if you are in any of the 16 western states, 17 including Texas because they've adopted the prior appropriation doctrine too, if you're any of the 17 contiguous continental states, there is no riparian zone because the riparian doctrine law applies only in the eastern part of the United States. That's what Rehnquist said in that California versus U.S. case we were just talking about. So this riparian doctrine developed in, it comes from the Latin word ripa, which means bank as in a stream bank. Well, basically what it means is that, that anyone who owns, it's a legal system that recognized that each owner of land along the watercourse had the equal right to the reasonable use of the waters that flowed through his land, which means a guy that lives in Minnesota on the Mississippi River has the same right to the use of that water as a guy that lives in Louisiana in New Orleans. Okay? But that didn't fit the West. That's why Congress adopted these two different systems. The appropriation doctrine developed in the western United States. It had its origins in Spanish and Mexican law. The first United States Western water law was Kearny's Code. Okay? The laws heretofore enforced concerning watercourses, stock marks and brands, horses, enclosures, commons, and arbitrations shall continue in force. It developed it was a legal system that recognized that the first person to put water to beneficial use, regardless of whether they owned riparian land or not, acquired a superior right to a later appropriator. You've heard of senior water rights, junior water rights. That's exactly where this comes from. So, by this act of July 26, 1866, 1870, the Desert Land Act, Congress severed the water from the public lands, and by the act of August 30, 1890, they established the 100th meridian as the federally recognized boundary of the arid region by reserving rights-of-way for ditches and canals on all lands patented after that date. This is from California versus U.S. That included all of these states, western states. Okay, the Act of 1875 made it legal to graze livestock on all public land that was open to entry and settlement. You've been told your whole life, well, Congress never passed a grazing act of 18 whenever. That's an absolute lie. It's right there, clear as can be. It's in United States statutes at large. It's the Act of March 3rd, 1875. What it says was that it was illegal to graze on any federal reservation, to open a fence or drive livestock on any federal reservation in order to destroy the grass or trees. And then the final provision said, however, this does not apply to any land open to entry under the preemption, homestead, or mining laws, which was the vast majority of all the land in the western United States. At that time, there were a lot of reservations, military reservations, where the Army came out and they'd set up a fort, and it didn't require an act of Congress because they were established by executive orders. Fort Stanton, New Mexico, Fort Lyon, Colorado. And these were huge because what they would do is they'd establish a post and they'd reserve about 100 sections of land. And the typical description was 5 miles south, then 5 miles east, 10 miles north, 10 miles west, 10 miles south. That was the description given in the executive orders. So anything within that 100 square mile area was reserved for military use. And Congress did enact a few of these as specific military reservations, and they called them timber and forage reserves. And so there weren't a lot of them, but it set a precedent, because then when the Army was no longer needed to fight the Comanches or Apaches or whoever, as soon as those posts were abandoned, Congress passed another act in 1884 to provide for the disposal of these abandoned military reservations. And so it set a precedent of how it was to be disposed of, because a lot of these reservations, they had allowed homesteaders, because you could apply and go in that reservation. If it wasn't an interference with the government's use, you could actually homestead. So there were 160 or 320 acre homesteads within these military reservations, and as soon as they were no longer needed, then the government would dispose them by selling them, and they could grant grazing privileges. This was included in the law. It says that the Secretary of War could permit grazing within these military reservations if it did not interfere with the government's use of the reservation. And it was under the title heading of granting grazing privileges. Now, that's what you've been told your whole life, right? That grazing is not a right, it's a privilege. Well, legally, when you look at the terminology, what is a privilege? Look up the definition. A privilege is an exclusive right. A privilege is a preferential right. And the way it's explained is that if I said the right to keep and bear arms, the benefit of being able to keep and bear arms is a right. It is. It's a right. Everybody can do it. Can everybody graze on one of these reservations? No, it is not a right. It is an exclusive right. It is a privilege granted to the people who meet the requirements of the statute, which was ownership of the water rights, ownership of the range rights. Those were the people who had the right to graze. So by definition, the word privilege doesn't mean revocable. The word privilege doesn't mean something they can take away. And by the use of the word grant in the statute, what does the word grant mean? It's an irrevocable gift. So the intent was never that you would simply be allowed to continue using a possessory right that was already established. Because all of these western states already had all these range rights long before the first Forest Reserve was ever established. And in the Forest Service Organic Act, the very first thing that it says is that priority will be given to surveying land occupied by actual settlers. That was the very first thing Congress says in the Forest Service Organic Act. So they already knew the West was widely settled, water rights existed, range rights existed. So, okay, what confuses people is the grazing fee. The fact that ranchers pay grazing fees contributes to the misconception that Western ranches have a leasehold value or that you're renting them. However, the grazing fee is not a rent. 25% of the grazing fee, and this started when they formed the Forest Service in 1905. They wanted to know, can we charge a fee? Because you know what, when we were under Department of Interior, when surveyors would go out to survey a homestead, they could charge a fee, okay, to recoup their cost, their administrative cost. Well, since they were no longer under Department of Interior, but yet they still had to do all of this surveying and mapping and recording of all these claims and everything, they want to know, can we charge a fee? So they wrote a letter to the Attorney General, said, we want an opinion. And if you go to the United States Code, the United States Code today, and you look it up, and you go to the footnote, that's exactly what they cite as authority, is an opinion of the Attorney General. And if you go to this case, U.S. versus Gramad, and you read what the Supreme Court said, that's exactly what they said that these fees are for. An administrative fee, 25%. 25% goes to the state and county of origin under the 25% Fund Act in 1908. And then 50% is a trust fund set up specially in the Treasury for building range improvements. Okay? It's a cooperative, it's called a Cooperative Improvement Fund. In 1914, okay? It was based off of the same concept that existed under the Reclamation Act. Any people that have been involved in these big reclamation projects, you know that the people that were the beneficiaries of the reclamation project had to pay for the improvements. The idea was the government would build them and then you'd pay them back. Well, with the Forest Service is the other way around a little bit, because then you'd pay into it first and then they would take that money and build range improvements. And in U.S. versus Gramad, the Supreme Court spells it out. That's what those fees are for. Well, here's some of the laws. I couldn't even fit all of them on there, but these are just some of the laws. We'll be here all day talking about all of them. So we're going to hit a few of the high ones. The Act of 1866, the Grazing Act of 1875, the General Allotment Act of 1887 was applied to the forest reserves by an amendment that Congress made in 1910. It would have been easy, you know what? It would have been easy if Congress had just sat down and wrote this whole law out in the very beginning. But they didn't. It was piecemeal. One year they'd write this, the next year this. As they needed to, they would pass this kind of legislation to take care of problems. Livestock Reservoir Site Act. So they say a picture says 1,000 words, and all you want to eat your lunch, so we'll just skip over to, and if you can just pay attention to this for a minute, then you'll get the whole idea how all these laws fit together. But say a homesteader comes out, takes up a 160-acre homestead. Now there's a creek that flows by his ranch. There's a couple of springs. He turns cattle out there under the state and territorial range law. He has a right to do so. As a matter of fact, in several Supreme Court cases, they said that these territorial laws were constitutional, that the state has a right to determine what constitutes property within the boundaries of their state. And so several of these range laws were tried all the way to U.S. Supreme Court and found to be perfectly valid and constitutional. So you turn out your cattle on your range, they drink out of the water. Under the Act of 1866, you have now acquired a water right, a stock water right. Okay, so right here, just by this one illustration, even though you can say, well, you know, you own 160 acres, you also own a range right. You also own water rights, stock water rights. Okay, the Act of 1866 also allowed for construction of ditches and canals. So now he's got him a ditch here. Okay, well, that's a right-of-way. And the limit was undefined. Later statutes define it as 50 feet on either side of the marginal limits of the ditch. So at the very minimum, you got a 4-foot wide ditch. At the minimum, you'd have a 104-foot wide right-of-way, and Judge Smith in the Hage case used 50 feet on either side. So now you've got range rights, you've got water rights, and you've got an actual right-of-way. These are all real property interests. And so even though the federal government owns the underlying land, they've passed these various laws authorizing settlers to go out there, because you got to remember, this was prior to 1916. This is all prior to 1916. This was under the classification system, where they did not want to give away these huge areas of land to ranchers. They wanted to leave it open for mining. They wanted mining to go on. Okay, so just at this point, you've got all these water rights. You've got right-of-ways for ditches and canals, for stock trails, okay, because cows don't fly. So how they get from every one of those water holes, you got to have a stock trail. Well, the Act of 1866 was the grant of highways. And you have to remember, these statutes are all interpreted in light of the meaning and the intent of Congress at the time. Let me ask you, in 1866, what was a highway? Were there any paved roads in the United States? Okay, if you look at Bouvier's dictionary from that time period, it is a place for driving livestock. That is a highway. So Section 8 or RS 2477 was originally enacted as the grant of a place for driving livestock. Okay, because people would establish these water rights, and then how would they get to them if some homesteader came along and homesteaded in the bottom of that canyon? There had to be a right-of-way, so they could still continue to make use of that property right. So under the Livestock Reservoir Site Act, Congress took it a step further, and they granted a 160-acre easement around every stockwater location. So now let's say you somebody has a ranch that's got 100 different stockwater locations. Well, that's 16,000 acres of easements just under this one act, okay? So by the time Congress got around to addressing how are we going to dispose of the land that is chiefly valuable for grazing and raising forage crops, this is what already existed under the laws that Congress had already passed. You had a right to construct improvements necessary to utilize your property, and that explicit language is in the Forest Service Organic Act of 1897. So ranchers started building fences, and they had a perfect right to do so, and under that Atherton versus Fowler case, the U.S. Supreme Court said so. Okay? So also they own the forage. Now how to show the forage on that picture there, I didn't know exactly how I would illustrate forage, but nonetheless, the Supreme Court said forage was a improvement. There's a lot of places in the West where there's Kentucky bluegrass, and when I worked for the Forest Service, they thought that was a scourge on the West, that there was all this Kentucky bluegrass everywhere all over the West. And it wasn't until years later I understood, well, wait a minute. The only way that could get there is if these ranchers knew they had this right to improve the forage, and they were throwing out Kentucky bluegrass all over the place. You know, so, and the Supreme Court said that was improved, that was an improvement. They said that even fencing or using riders to keep cattle off of a particular piece of range in order to allow that grass to grow up, to use it for spring or fall or winter feed, constituted an improvement. And so if you look at the definition under the Federal Land Policy Management Act of what constitutes a range improvement is any, let's see, I'm trying to think exactly how it's worded, any project or program that improves, that results in the improvement of the forage. So even a rest rotation grazing system is an improvement. And what does FLPMA say? FLPMA says that if a permit is canceled in whole or in part to devote the land to another use, the permittee shall be compensated for the value of his improvements. It doesn't say the value of a permit. So I agree, a permit is not a right. A permit's a piece of paper, an authorization. Okay, and in that case of U.S. versus Gramad, the Supreme Court said the Secretary has authority to regulate occupancy and use, and that's exactly what the Organic Act says. So they can regulate, but they cannot take your property. Okay, people have asked me what I would consider a valid provision to be in a government permit. Well, since they own the minerals, I guess if they put in there that you agree not to do any mining without their permission, or not to allow your cows to dig any holes for gold or something, I suppose that would be a valid provision to be in there. I have a copy of a 1920 Forest Service grazing permit. And there's only 3 things on there. On the back of it, it says, I agree not to start any fires. I mean, it's a little more, it has a little more wording than that, but it says, I agree not to catch the forest on fire. Why? Because in 1909, Teddy Roosevelt said, we're going to create the split estate. The government's going to keep the timber, we're going to keep the minerals, and the ranchers get the grazing. Okay? So that's what was in the permit. It said, I agree not to catch anything on fire. I'm not going to burn up any timber. The second provision says, if a fire starts, I will help put it out, and the government will pay me. That's what it says. We will pay you and your employees for helping us put out the fire. And then the third provision says, unless, of course, I started the fire, and then you guys aren't going to pay me, but I'm going to help put it out anyway. That was all. That's all that's in that 1920 Forest Service grazing permit. The only requirements that were in there. Okay, so essentially, in the Hage case, when I presented this to Judge Smith, he agreed with all this. Ranchers own the water rights. They own easements and right-of-ways of various kinds under these different acts of Congress. They own the forage, the grazing allotment. Judge Jones gave us a gift on that. That's why they had to crucify Judge Jones, because he ruled, and a lot of people miss this, one of the very first things in his opinion, he ruled that as a matter of law, that these were units and allotments. And unless you know what the word unit means, it would probably just go right by you. But what is a unit? It is an actual area of land granted under the homestead laws, the Stock Raising Homestead Act. A lot of people think that act only granted 640-acre homesteads, but if you read the congressional record and the report that accompanied it, if the land was suitable for support of a family for 640 acres, a homesteader could go in there and homestead 640 acres. Otherwise, it required a determination. The government had to go out and lay it out and mark out the boundaries of the amount of land actually occupied by the bona fide settlers. And that's why when they first created BLM grazing districts, you had to go in and make an application, then they would give you a permit, then they would go out and they would map out the extent of your allotment. Look up the word allotment. The word allotment, the Supreme Court said, is analogous to the word homestead. It's an additional entry under Section 8 of the Stock Raising Homestead Act because it was an amount of land sufficient for the support of a family. Congress, you got to read that Watt versus Western Nuclear case. It is so cool to read these Supreme Court justices talking about the fact that Congress didn't have any qualms with disposing of this 600 million acres of land because that was their intent from the very beginning. It was the minerals that Congress so sedulously wanted to retain. Because, man, there's a lot, you got to admit, in the West, there's a lot of value out there. Oil, gas, coal, gold, silver. So Congress, they purposely created a split estate in 1916. And the Forest Reserves actually under an act that Congress passed 2 years before in 1914. And that's how, and if you read the congressional record for the Stock Raising Homestead Act, the Secretary of Agriculture is quoted in there saying, bragging on how we've granted all the grazing rights in the National Forest. He was required by the end of 1914. In 1910, Congress passed a special law calling for an investigation, a congressional investigation of the Department of Interior, Department of Agriculture, and the Forest Service, because of all the abuses that they were inflicting on people in the West. And so they spent the whole summer of 1910, you can go in the congressional record and look at this, look at all the hearings they had from people from the West coming to Washington, D.C., complaining about what the Forest Service and these federal agents were doing to them. And so in 1912, Congress passed a special act which required and directed the Secretary of Interior to dispose of all land within national forests more valuable for agriculture than for timber purposes. And that is when they created all the grazing allotments in the national forests, and that was a disposal, because the Stock Raising Homestead Act does not require the issuance of a patent. So what it requires is a determination and a survey. And so your allotment map is the evidence of the grant. The act of Congress itself is the grant. The executive branch, who has the power under Article 4, Section 3, Clause 2? Congress. It's plenary. Congress has the power to dispose of. And the Supreme Court has said the executive branch can do nothing except what Congress authorizes them to do in regard to disposal. Okay, so we are here today with this idea that the government still owns everything out there. And it's only because we have believed their narrative of what they've been telling us all these years instead of reading what the statute says. But Congress has disposed of the service's grazing allotments. Now, in Watt versus Western Nuclear, and Judge Jones made the same comment when we were in the trespass case. He said he wasn't going to give them the service estate. He wasn't going to give them the whole service estate. It is a limited title for agriculture, and that's what it says in Watt versus Western Nuclear, for agricultural and ranching purposes. But the fact that people don't know the law and they don't know how to articulate that when they get in front of a court. When I worked for the Forest Service, every single time a rancher got hauled in front of a court, the accusation was that they were trespassing or illegally grazing on public land. And what is the legal definition of public land? Land upon which there are no rights or claims. Well, you've already slit your throat already if you stipulate to that. If you go into court, and that's why they, at first, and Ramona can verify this, the first thing they wanted to do when Wayne went in and made the property rights argument, they made a motion to dismiss. They brought the case, they spent all these years getting ready, and they were going to crucify him in court, and they get him in there, and he brings up the property rights argument, and they say, we make a motion to dismiss. We want to drop it. Because they do not want this to be brought up. There are two cases they always cite every single time. Light versus U.S., U.S. versus Grimmaud. Now, there were 18 Supreme Court cases on range rights between 1885 and 1918. 18 cases, and the only two they ever cite is Light versus U.S. and U.S. versus Grimmaud. And the reason is because the two individuals involved in those cases didn't own any range rights. They were trespassers. But the same year as Light versus U.S. and U.S. versus Grimmaud, less than 6 months later, the same 9 justices that rule against Pierre Gramade and Fred Light now rule unanimously in favor of J.B. Curtin. Why? Because when J.B. Curtin went in front of him, he said, I got 23,000 acres of range. I have right-of-ways under the Act of 1866, and I have property rights. And the same 9 justices that just 6 months before in companion cases ruled against Pierre Gramade, who was a tramp sheep man at that time period, those were individuals, they'd just buy a big band of sheep and just start herding them across country, wherever he wanted to go. He didn't own any water rights. He was not a bona fide settler. He did not have any right-of-ways. He did not claim any range rights. As a matter of fact, one thing you cannot find in Justia or even Casemaker for any attorneys out here, you have to look in the lawyer's edition of the Light case to find it, but they give the lawyer's argument, and the very first thing the Solicitor General says, he says the appellant, Fred Light, has no right to challenge the Forest Reserve or the reserve policy because he claims no prior existing rights. So I'm just going to skip down. Okay. This is FLPMA, Federal Land Policy Management Act. A whole section, a whole title. There's 7 titles in that act. Title 7 says, right down here at the bottom, if you can read that, it says, all actions by the Secretary concerned under this act shall be subject to valid existing rights. Congress knows these rights exist. This is a National Forest Management Act, passed the same week, actually the next day. Okay, October 23rd, 1976. Down here under section I, the very last sentence, it says, any revision in present or future permits, contracts, and other instruments, contracts, and other instruments made pursuant to this section shall be subject to valid existing rights. It doesn't matter what's in the forest plan. It doesn't matter what's in their permit. It doesn't matter what's in the resource area plan. All actions by the Secretary, all future, present and future permits, contracts, and other instruments are subject to valid existing rights. So what do you need to do? This is it. Do a title search on the history, the documentation on your ranch, including the homestead, the headquarters, and the allotment. Is because of the hard work Ramona and her mom put in to being able to come up with 300 pages of documents that Judge Jones had no choice but to rule in their favor. Okay, number 2, locate by legal description or GPS every stock order location on the homestead and the allotment. Make sure that all filings, not fillings, they should be filings, and claims are up to date. Number 3, document all communication with federal agencies and reply with your position and understanding. Otherwise, you go into court and they say, well, we never said that. Or they go in and they say, well, he threatened us. You need to, I don't want to say once a month or every time, but you need to write your version of whatever communication you have with them. And you need to send it to them registered return receipt, because that becomes part of the administrative record. And if you ever have to go to court and there is anything that you have mailed to them that is not in the record, that means their whole record is now tainted. They come into court with unclean hands. So document your communication, send it to them registered return. Do not sign anything you don't agree with. If they say you got to sign this permit, just line out everything that you find offensive. If you don't agree with something that's there, line it out. But don't sign anything you don't agree with. I think any attorney would tell you that. You never sign anything that you don't agree with. So you don't have to burn your permit or tear it up or bury it, but if you don't agree with it, don't sign it. If there's something, now if there's something there that says my cows will not conduct mining operations, okay, I can go along with that. Okay, my cows will not cut down any timber, commercial timber. I can agree with that. Okay, if they have something in there about endangered species or the environment, well, guess what? U.S. versus New Mexico, U.S. Supreme Court, not me, said national forests are not established for environmental, wildlife preservation, or aesthetics. The Supreme Court said that, not me. But, you know, don't sign anything you don't agree with. And finally, join with like-minded ranchers. The people you associate with here, the people in your local ranchers group, that's what you need to do. I'll just leave that up there.
Angus, did you just say that it's unconstitutional to call Native American, Indians Native Americans?
What?
You said it's unconstitutional to call an Indian a Native American.
Oh.
Thank you, Angus McIntosh.
I didn't, it's not unconstitutional. I'm just saying that there's a classification under the United States Code that's entitled Indians. But that's just the title they gave it back 100 years ago.
Right.
And they haven't changed the title of any of these. There's 53 titles in the United States Code, and they haven't changed any of them since they first established it 100 years ago. So the fact that public lands are a myth, that there really aren't any public, I'll address that one question there.
I was trying to lighten it up before we have our lunch, and now you're going back to
I'm going to
heavy
address
metal.
that one thing. I'm going to address that one thing. The that idea of public lands. In 1970, Congress commissioned a public lands commission, and they came back with a report. And in that report, they came back and they basically said, there are no more public lands. Everything in the West has something attached to it. It's withdrawn, it's got a right-of-way, it's got water rights on it. There is no public lands. So in 1976, Congress changed, by statute, the definition of public lands. And so if you go to FLPMA, it defines public lands, because what is that? The Public Lands, our Federal Lands Management Policy and Management Act. Okay, they define the term public lands. They said public lands are lands and interest in land that belongs to the United States. So now, that could be anything. It could be a mineral right. It could be reserved timber. So it was no longer just this term land, but now any interest in land belonging to the United States. And throughout FLPMA, you read it, and the whole thing says land and resources, land and resources, land and resources. And that word "and," that connecting word "and," in plain English language in the law means a separate thing. So land and resources are not the same thing.
Your salad's getting cold. Thank
Okay,
you, Angus
thank you.
McIntosh.